The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon or morning, everyone. This is Laura Stewart, Director of Online Channel Events for SASMAX, and we're going to be getting started shortly. If you have any questions, please feel free to enter them in the question box, or if you have something that needs immediate attention, please put it in the chat box, and one of us will respond to you as soon as we can. We'll be starting shortly. We're going to be starting HIPAA compliance, what's my role as an IT service or solution provider, in just a few seconds. So make yourself comfortable, everyone. We're going to have an amazing webinar for you today with Clint Gatewood, VP of Channel Development for SASMAX, and presenting Mark Haskelson, President and CEO of Compliancy Group. So we're just about to get started. Welcome, everyone, to SASMAX Presents Crossing the SASM, HIPAA Compliance, What's My Role as an IT Service or Solution Provider? We're really excited to have one of our vendor partners here with us today to educate the channel on HIPAA compliance, what it means for you as a service provider and as a service. Having been an MSP for over 15 years prior to selling my company with a vertical in healthcare, this is such a critical topic. And I just love the fact that we've been able to get Mark Haskelson to actually give us an educational webinar today on this really critical topic. And you'll understand why in a little bit as he starts presenting. Our agenda for today, if my keyboard would be willing to cooperate with me, and it has decided to not move. So let's just change that here and see if this works a little bit better. And there we go. Our agenda today, we're going to start out talking a bit about SASMAX, and then we'll introduce Mark Haskelson, who will do an overview of HIPAA, what is a business associate and HIPAA, and why is it important to you, and how you can learn more about what we're doing here. So now I'd like to introduce Clinton Gatewood, our VP of Channel Development for SASMAX. Clint?
Thanks, Laura. I want to take a moment, too, to thank Laura for everything she does here, running all our online events. She does a great job. I've known Laura for, I hate to say how long, and I won't, but Laura is also very knowledgeable of your business model. She sold her MSP a while ago, and she really focused on healthcare clients. So she has a lot of knowledge in this particular field as well. So I just want to thank her. She has her own radio show. You can follow her on iHeartRadio, and she does some speaking engagements around the country. So great person to follow. Professionally as well. So just wanted to shout out and say thanks, Laura. So one thing I do want to talk about, we're not going to talk a lot about SASMAX today. We're here to talk about HIPAA and what it means to you, and are you covering your clients, are you covering yourself well? And we got Mark here to do that, which you're going to love the guy. I've known him the last 4 or 6 months, and he knows his stuff, well respected in the marketplace. But before I get to that, I just wanted to also let everyone know that we are highly focused on CCaaS, or software as a service type applications as well here at SASMAX, and we're having our cybersecurity channel roadshows. So we'll be looking for those coming to an area towards you. If you happen to be in the Dallas, Boston, Chicago, Atlanta area, and I would like to attend, please contact me at the show. We will be sending out everybody invites shortly, so you can save the date. They're great events. They're a half-day event, a little bit longer than half-day. They go from about 2 o'clock to 7, 8 o'clock in the evening. And just a lot of great thought leaders coming out to present security, but it's a great event. It's high energy. We have them in some nice think tank workspace type areas, and everybody gets to participate. It's not like you're being spoken at or going to an old hotel room or something like that, like all the old stuff. It's really energetic with some really great people in the room. So mark your calendars if you're in these particular areas. You're really going to want to come to this. And then we'll move on just a little bit more about SASMAX here. So this is just what we do is we work with software as a service, ISVs, vendors, however you like to term them, and we work with them to understand their business model, the type of partners they like. We also have partner success managers on staff for our solution provider audience, such as you, where we'll work to find different products. You can call us and say, I'm looking for a product for XYZ. You call your partner success manager. He'll help find you the right products and solutions, whether or not they're part of our marketplace. So we do a lot of R&D for our channel and working with them, and this is some of the people we work with, some of the brands that we work with today. From I'm not going to talk about that today. You'll be hearing from us. It is my distinct pleasure to introduce Mark Haskellson. I always put an R in it. And we just talked about before I got there, but Mark Haskellson from Compliancy Group. He's been a professional in a consultant, and he'll talk more about his experience than I have to, but he's been doing it for many years and has a great company and practice built around this. So Mark, the show is yours.
All right, thank you, Clinton. I appreciate it. Laura, thank you for hosting this. Before we get off of SaaSmax, those meetings they have, those lunch and learn events are fantastic. We've participated in them, and we've gotten great results both in the sharing of information with the attendees, and I think as a vendor, it was also a great business opportunity for us. So, okay. Couple of things I promise you today. I will not bore you with all the details of the bits and bytes of what 164-3B equals from a compliance perspective. Okay, what I'm really going to do is talk about you as a business associate, and I'll explain what that term means. What does this really mean to you? Where are the big misunderstandings? And then ultimately, why this is important to you and your clients, okay? Because some of this is what may not be that big a deal to you is actually critical to the relationship your client has, okay, or the client has with you. So please do ask questions. I'll do my best to get through them either, while I'm, for a particular slide, I might wait for like the next one or two or finish a point. But please do ask questions. There's no such thing as a bad question. I have heard all sorts of strange ones. So, I'll give you the let's see if we can stump Mark today challenge. If anyone's got a good one, I'll take it. Okay. So, first thing I want to talk about is something that I don't think a lot of people realize, okay, and that there is something called when you have a meaningful breach, okay, when something goes wrong, your clients are mandated to report that to the U.S. government, okay? It's called the HHS, Health and Human Services. That's where HIPAA law comes from, okay? Their enforcement arm, by the way, any acronyms I use today I will try to define just in case there are folks that are not familiar with them. But OCR, the Office of Civil Rights, is the enforcement arm of of what is HHS or HIPAA, or the HIPAA police. Now, what happens is, I want to stress before we get started what this means to you. So the HHS wall of shame, any meaningful breach that occurs where potentially more than 500 people are affected, by law must be reported within 60 days of the notification of that event. So if you look at this list, all right, first of all, right off the bat, I can tell you right now, of all the breaches in the United States, 20% are caused by the business associate, okay? So just a quick one we pulled here, this is just BA incidences that have happened, just even part of last year or in the last 6 months or so, okay? So now understand, if you're on this wall of shame, first of all, any of your clients, vendors, and although I'm not opening up the views, yes, your name will be listed here if you were involved with the incident and what was the cause, okay? So whether it happened in your infrastructure or it happened within your client's infrastructure, you do not want to be on this wall. Okay. The other thing about this, if you report it on this wall, I can tell you without a doubt, you are going to be audited, and under what's called the Phase 2 audit, under the Phase 2 rules, I'll explain more about that later. If your client did it and got audited and failed, you will get audited. You fail, they will then audit all of your clients. Okay, so these are some changes in the rules, and I'll explain more what changed in the last 2 years and why HIPAA and being a business associate and BA agreements and all those things really should matter to you. Okay, so the next thing I want to talk about is I hear people tell me, oh, we never make a mistake. Are you kidding me? We are bulletproof. Well, guess what? Statistics say, can't speak today. Statistics say 59 of you have had at least one breach in the last 2 years, and 29% of you have had 2. Okay, so you are now a serious vulnerability to what is the concept of healthcare in the United States and the information exchange of it. You are, and why the reason the law was changed is you are a serious liability to us. or to the community, or potentially to the community. Okay, and I'll talk when I go into kind of the misunderstandings and how that affects you, why you should care, which brings us to the next slide, why you should care. For years, I heard people saying they never audit, you'll hear doctors saying, or covered entities saying, they never audit small organizations, they only go after big hospitals. And I can tell you, umpteen business associates, either MSPs or just general BAs, vendors in the market, that, you know, touted, they're never going to look at me. Are you kidding me? Well, guess what? They did. Okay, and last year, which was the first time in HIPAA history, a business associate was fined. Okay, in this case, it was an IT service provider. They were part of Catholic Charities, so they weren't a true traditional MSP, but they were a captive IT group that serviced the Catholic Charities groups in the Philadelphia area, to be exact. Okay, what was the violation? An iPhone, right? Doesn't seem like a big deal, but if you think of statistics, 1 in 10 iPhone or smartphones will get stolen in a year. So there was a pretty high likelihood that in your staff, a phone could get stolen or lost. Now, because it's a meaningful breach, and I'll talk more of what that means, it was reported to the U.S. government. Second thing I want to stress to you, so if you don't care about the embarrassment or loss of reputation, you should care about the financial implications. $650,000 is not exactly an easy thing to overcome. And by the way, because this was a nonprofit and a service organization, the director of OCR said point blank, this would have been a much higher fine. This most likely would have been, I would say, in the world of what I see in other fines, somewhere in between $2 and $3 million worth of fine normally. Okay, and by the way, I apologize, I didn't get this. So my firm, what we do is we sell compliance as a service tracking solutions. We have thousands of clients across the country. So when I say that these things are really going on, I'm talking from experience of the 100+ OCR CMS audits we have been directly involved, of which I can say proudly, no one's ever failed. Okay, of our people. All right, so when I say these are the tricks of the trade that I'm going to give you today, I mean it. So now, one of the next thing I want you to understand when we talk about fines, the government does not fine anybody for the breach. Okay, it's not the lost laptop or the stolen iPhone. What they fine you for is for not having an effective compliance program. Okay, the government never expected you or your clients to be bulletproof, okay, but they did expect you to have the basics in place. So if you look at this one, and this is going to be a common theme when I talk about real-world examples for you and what you're going to see your clients dealing with, okay, they were fined not for the lost phone, even though it was unencrypted, even though it was not password protected, which is just insane, right? What a simple thing to fix. The real thing they were fined for was lack of policies and procedures. Okay, and by the way, not security policies and procedures, but overall administrative and privacy as well, and I'll talk about why that's so important. Okay, the next thing is not having correct risk assessments. Do you know how many people I speak to in healthcare, MSPs, and clients? All I needed was a security risk assessment. I am all set. Guess what, folks? That is a really small part of HIPAA compliance. I'll show you what you really have to be worrying about in a minute. So in general, just appreciate that you are no longer exempt. For example, under the phase 2 protocols, on November of last year, 20,000 business associates were notified that they are now in the random pool to be audited in 2017. Okay, so this is no longer something, the statement I make at a lot of the events I speak at, you no longer should be considering if I will get audited. You should be planning for when I get audited. What am I going to do? Okay, so let's do a little definitions. So hopefully I got your attention that now you can appreciate that this is something you really should be paying attention to. Okay, so real quick, depending on the level of experience of folks in on the call, the definitions you as a business associate need to care about are there is a covered entity. That is a doctor or an insurance provider, by the way. An insurance, people who are involved in what is either treatment and or payment are considered covered entities. Okay? A business associate, on the other hand, which is what you guys are, is anybody who provides a service in any way to a covered entity who that in part of that service, okay, you are either creating, receiving, maintaining, or transmitting PHI on behalf of that client. Okay, and I'll treat you later. We'll talk more about what that means. But you know, for the people who I've had many a debate with folks who are like, I don't think I'm a business associate because you're a business associate. Sorry, guys. And it has nothing to do with whether or not your client asks you to sign a business associate agreement. If you have a single client in healthcare, by the way, client could be covered entity, client could be a billing service, a lawyer, an accountant. There are many, many different folks. You are now responsible to be HIPAA compliant, and I'll talk about what those responsibilities are. The last definition I think is important because we are talking to BAs on this call today is what's called a subcontractor, which means if you engage with a client and you're using an RMM software, okay, technically that's, or you have, you're using, let's say, a remote tech, you know, there's someone you know, you bring in techs to support you, you sub out deals, understand you are responsible for that subcontractor. Okay, and I'll talk about what that responsibility is, but you have a responsibility under HIPAA to make sure that that person is also protecting the PHI, the protected health information that you are responsible for. Okay, so now I'm going to talk a little bit about what's HIPAA. Okay, I am not going to go into the boring 738 pages of, you know, 164-B, 145, whatever. Okay, let's just keep it simple. There's a basic premise that starts off with what I call a fundamental misunderstanding of what is compliance versus security, of which then I'm going to go into explain what the law requires and some of the big impacts. So if we could talk about compliance versus security, next slide if you could there, Laura. Hopefully it's going to go there. Okay, so one of the big misunderstandings that I see almost immediately unequivocally across the market in every, you know, we're endorsed by 40 some odd medical specialties. I do work with every major hosting service, every major EHR, every major consultancy I interact with, and almost every single time I hear the same misunderstanding. I did a security risk assessment, therefore I'm HIPAA compliant. Sorry folks, it's not how it works. Compliance and security are two very important but separate entities, okay? And there are many intersection points, okay? And there's many parts of security that really are directly related to compliance, but they really are two separate things. And the way I explain it to most folks is, or I find the easiest way to explain is, compliance is binary, okay? It's a federal law. You must satisfy it. It dictates several specific things that you must do. And at the end of the day, you must be able to prove on an annual basis every year that you did or did not do these things, okay? If you don't do that, you get fined. Simple as that, okay? Now, security, on the other hand, you are all security experts. I know a fair amount, but I don't profess to be an expert in security. But the way I think most people need to understand it is security is about risk, right? You know, there's a risk if you don't do security well, you run the risk of your information, data, stolen, corrupted, etc. Okay? Now, to the average user, like I said, they often think that's the same thing. And the reason why it's so important is I can make you compliant with policies and procedures. And a simple example would be encrypted email. Okay? The law says if you are going to exchange in any way information, it has to be in a secure fashion. So you could write a policy that says there will be no PHI ever emailed to a patient, okay, or to a doctor. We will not ever use that medium. But you're not very secure because chances are, let's be realistic, folks, if you looked at the wall of shame and the whole wall of shame, you'll see, you know, the majority of the fines are for theft or for loss. You know, they're human mistakes, okay? They were not systematic problems. So it's really important that you have these things in place. The opposite is you can be highly secure but in no way compliant. And that's normally what I see when I see people saying they did security risk assessments. That's why they're all set. They don't need to worry about their HIPAA compliance. Okay, so next, let's keep talking about all the fun things you have to worry about. Okay, so what is HIPAA is really, as a law, has three parts. Okay, the first thing is what is your privacy rule, which does not apply to you. Okay, it really applies only to the doctor's office and in their course of treatment, the dialogues they're having. Okay, security, on the other hand, and actually, if you could, Laura, if you can click that, make that expand. Okay, security is made up of three parts, and this is where most people get in trouble. Okay, in that they presume that the security risk assessment they did for things like meaningful use or just wise security programs made them HIPAA compliant. That is not the case. There's actually 3 parts to the security rule. There is a security audit, right? These are technical, and also, by the way, there is a second audit, which is a physical audit, often confused with security, because you can have the most buttoned-down server, but if the server room is not a locked room where people understand that it's not okay to put a garbage can in front of the door because it's kind of inconvenient to open the door every time, that's not acceptable. Did you look at those? Did you audit to see if those type of things, are there file cabinets in hallways, which is not acceptable? Okay. The last thing is really the administrative audits, okay? Or notice the language is similar because it's also referred to as privacy, okay? In that, but this is not the privacy rule. What this says is you have to have policies and procedures to make sure things are done correctly, okay? Or, I'm sorry, you audit your organization to make sure that there's not systematic failures going on. Like the, what do you mean it's not okay for me to leave my laptop in the car overnight? Okay, on the dashboard, front seat, unlocked, keys in ignition, kind of crazy stuff, okay? Now, I mentioned a lot of people misunderstand meaningful use and the calling for, but first off, I'm not going to go deep into meaningful use because I don't think it's that important for you. It is important to your clients, any covered entity, many of them, in order to get the maximum payment for Medicare and Medicaid, they have to attest to meaningful use. It was an incentive program. It is not a law. Okay, they're not required to do it, but because the government always thought everyone was HIPAA compliant, they were satisfying these 3 rules. When they put in meaningful use, which was the deployment of electronic health records platforms and the sharing of data, they figured it was pretty easy to say, hey, you got to make sure you're secure. Okay, but often people misunderstand. It is the #1 misunderstanding I see. I get on the phone with somebody, they call our offices and say, I just need a security risk assessment. I don't need all that other stuff. Okay. They need a security risk assessment, and if they were already HIPAA compliant, they would have already addressed this and had it ready to go. Okay, and actually, just to give you a sense of scope and scale, there's a mandatory audit of 5% of people who test for meaningful use, and the failure rate is 79%. Single biggest reason, they were not HIPAA compliant. They only satisfied the security risk assessment, not the rest of the requirements. Okay, now the last part, breach notification. Actually, since Laura just hit the X there, FYI, the privacy rule, which has to do, not to be confused with the privacy audit, the privacy rule has to do with how a doctor is communicating with a patient. Okay, you are not responsible as a business associate, okay, to the privacy rule, but later when I explain your liabilities, you are responsible to help your client satisfy the privacy rule, and I'll explain more what that means. So, breach notification rule changed a little bit about 2 years ago. Officially, it changed dramatically January 1st this year. Okay, what the breach notification rule says really 3 things. Any incident or breach for you or for a covered entity, okay, remember, the only thing you don't have to worry about is the privacy rule. The security rule, the breach notification rule, you are 100% on the hook for, okay? Now, so the breach notification rule, what that says is if you have any incident or breach, you must investigate it. That's required by law. Once you've done investigating it, there are only 2 options. You either, if it is a meaningful breach that potentially, notice I said potentially, more than 500 people were affected. So that's, hey, you lose a phone or a laptop. Doesn't matter if it had a password on it. Unless you can prove that there's that day that there was no way for anybody to get access in any possible consideration, that's considered a meaningful breach. Okay. Now, a non-meaningful breach is anything that was less than that. I misplaced a record, we mailed something wrong, etc. In those cases, what happens is you still must investigate, but at the end of the year, the end of the calendar year, you then report it to the U.S. government. The reason why I say the law changed is January 1st of this year, there was a 2-year grace period that has since ended. January 1st this year, every covered entity and every business associate within 60 days is supposed to give a report to the U.S. government of all the incidences you had and how you remediated them. Okay, most people don't even know that that is in place. I do think historically, as the experiences we've had with HHS and enforcement, they won't do much with it this year, right? But I will tell you, be ready in January of 2018 that if you don't do it, The fact that you don't report anything in some ways will be telling the government that you either are hiding something or you don't understand the rule. Either way, you're upping your chances of getting audited. Okay, so we beat this one up well enough. Let's go to the next one. Next one says, for those of you who are not going to spend a lot of time on this, this is what is considered PHI. So when you turn around and say to me, when people say, well, I just sent the name and address, well, guess what? That's PHI. Another one I get often is, well, we had unique identifying numbers. That's not PHI. Yes, it is. Okay, account numbers, a picture. All of these things are considered PHI. So this naivete that I often hear, well, what was the big deal? We sent whatever it was, okay? Or one of my favorite ones is a CPA, an accounting firm that says, we don't look at any, we never see any PHI. We don't have to be HIPAA compliant. I'm like, take a good look at that QuickBooks feed. I have a feeling you're going to be mighty upset just how much data was in it. Okay, so just high level, these are all of the elements that are considered PHI. You're all very smart people. I'm sure you can read them, probably much faster than I could go through them, but it is a lot more than what you normally expect. A lot of people think that, what's the big deal? It is a big deal. Now, one thing as we go on to the next slide is if I choose to, if doctors' offices have something called use and disclosure documents. I'm sure you have all gone to the doctor, and when you went there, they had you sign that HIPAA document, okay? What that HIPAA document really is supposed to say, right, if you ever bothered to read it, was they're asking you where and when can we talk about your information. So can we leave a voicemail at your house? Can we email it to you? Can we discuss it with your significant other? Okay, those in that. So there is a. The reason I bring it up is often people are flustered by this, right? Does that mean I can never use anyone's name when I'm in a waiting room? No, as long it is how much you as an individual are comfortable letting them share. Okay, so let's talk about. We've talked about the rule. Now let's talk about omnibus. Now the reason why you people are on this phone and the reason why you care, okay, is that at the end of 2013, the omnibus rule was put into enforcement. Okay, and what it said was really the only lots of gobbledygook, but the three things it said is you as a business associate must satisfy the HIPAA law. Okay. 2, it said you and or a covered entity. Okay. Both you and covered entities. Before you can share PHI, you must have a business associate agreement in place and have done some sort of technical due diligence that these people can protect the information you're sharing. Okay. Why this is so important is I'm going to talk in the next couple slides about actual fines. Understand a covered entity cannot do business with you without a BA and having done this. It is against the law, and you'll see every enforcement effort last year, $24 million worth of fines. Every single one of them had something to do with not having business associate agreements in place or not having correct BA agreements in place. Okay, and by the way, this applies 100% to you, just like the covered entity. The last thing, which is the breach notification rule, I explained to you a little earlier that the law changed a little bit, but yes, meaningful, anything with potential 500 or more people affected, reported within 60 days. By the way, if you say to yourself, okay, for those on the call, hey, let's be clever, maybe we won't turn it in, how would they know? $475,000 fine to a group for not notifying the government of a breach, okay? And it was not a meaningful, it was a meaningful breach, but it wasn't anything horrendous. It was they lost some paper records, and when they found them, unfortunately, somebody else found them first. And when they were found, it was considered, it was reported on them. Okay, so dude, most of the fines you see, man, you could have avoided it with the simplest of things. Okay, so it's important. Okay, so let's move on to some, what is an effective compliance program? So the federal government, realizing that HIPAA had to apply to everything from a solo practitioner, a physical therapist who worked by them in their basement, okay, as well as a hospital, and now, after omnibus, to vendors, they realized that the law was gray and that it was the guidance that was provided was what's considered effective for me may not be effective for you. Okay, so in other words, you as an MSP and what's going on with you, what you do every day is different than what a doctor does every day. So for example, if you look at the 7 elements, and I'm not going to go deep into them, but high level, I think you get the concept, okay? And that is, it's got to be in writing, okay? So saying you had a staff meeting discussing HIPAA doesn't count, okay? There needs to be a compliance officer, and what they mean by that is not that you have to have a advanced full-time person on your staff, but the nature of compliance is you have to have somebody that people can go talk to, whether it's a client, whether it's an employee, that if they feel that there's a HIPAA violation going on, that they can speak to in private, okay? And that person, whoever it is, has to have the ability to go directly to you, senior management, or depending if you're senior management, and speak without fear of retribution, okay? So effective training, education, lines of communication, monitoring and auditing, these are common sense things, okay? So for example, here's where a lot of people make a mistake. No, it's not okay to just have a annual, well, I'm sorry, it might be okay just to have an annual training. It might not, and I'll give you examples in a minute of what's a might not, okay? Communication is, hey, listen, everybody has to know these rules and everybody has to follow them. Monitoring and auditing, by the way, is not just software. I think most people, their first blush when we discuss this is they think of, logging, audit logs of logins. That is a piece. What about just simply is no one's supposed to be here on the weekend. Why was somebody in on the weekend, and did they access records while they were there, right? Remember, when you got RMM equipment, right, you could be logging in to find out, your ex-spouse's medical records if you're clever, okay? And that's why why your folks have to be HIPAA compliant. Enforcing standards, everybody follows the rules, by the way. This applies, HIPAA does not just apply to staff or compliance officers. As I show you what's required in your organization, everybody from the president to the janitor have to go through this. The last thing, which is responding to offenses, hey, that's breach notification, right? Something happens, you've got to tell the government, got to fix it. Okay, so if you could bring me to the next one. Now, why should you worry about this? And well, it's a law, okay, you get that. But often people misunderstand, and the classic example, and this is a real-world example of a behavioral health group in Alaska, okay? They had a minor malware breach. Their answer, they had to report it, their answer to the government when the government did what's called a desk audit, which said, show me your assessments, okay, and show me your policies, your procedures, etc., remediation plans. They had security risk assessment, but they didn't have the required administrative and privacy, okay? They had policies and procedures, but they had purchased them as a manual, okay? And the government was not happy because when they looked at the policies and procedures, two things. One, they did not adequately reflect the business. They were manual, right? They were generic. Two, the law says you have to review them every year and make sure they're current. And they had not reviewed them because they bought them as a manual 3 years earlier. They had never reviewed them. Okay. The third thing they got in trouble for, and this is the training example I wanted to give you. This particular organization had very high turnover. So when they said, well, we have this great third party, we pay lots of money for these people to come in and train us every year, the government said, yeah, but that's not effective because your turnover is so high. That means there's a 30% of your staff could be going a year or more without training. So what was effect now, you could be in office and you say, listen, I have no turnover, so my annual training might absolutely be 100% effective. But that's the kind of stuff when we go back to, you'll hear this concept in when you see fines, is that it wasn't for the breach or the incident, it was always for, did you have an effective compliance program? Okay, so the other thing that you see if you look at it visually, so they had their security risk assessments, they had policies, procedures, and training, but all those question marks they were missing. And I'll explain those question marks in a minute, okay? But it is important that you understand this is all stuff that has to be managed, okay? It is not an option. This is like driving without a license or driving without insurance. Yes, you can do it, but if you get caught, is it worth the price? Okay, because one of the things that I'll stress, whether you do it yourself, whether you use the tools that are available on the market, you really have to be doing this. It's not an optional thing for you. Okay, so one of the problems we see many people facing is that the tools in the market are often for pieces of compliance. Okay, so for example, some people will say to me, well, we have rapid fire, we don't need this. Rapid fire is an incredible tool, but it's a security tool. Okay, there's nothing wrong with it, but understand that's great. You did your security risk assessment. Maybe you had the policies and procedures in regards to security and training, but what about the rest? Privacy, administrative, business associate management, incident management. I'll talk about what all those things are. But if you don't have them, you are not HIPAA compliant. And if you are implying to your clients that they are, you are basically grossly negligent. Okay, and I can talk about fine schedules, but understand, you could have a HIPAA breach and you could be fined nothing or $100. If they consider what you did grossly negligent, it's $50,000 per record involved in the incident. Okay, so it's 500 records multiplied by 50,000. There you go. Okay, so the next big so pieces of compliance or training programs or policy and procedure management programs, all great, but you really need to be doing all of this. You cannot just do pieces. As far as enforcement goes, and I can go very deep into enforcement, I'm going to give you a couple of real-world examples, but the simplest thing I will say to you is this is a cash-generating event for the U.S. government. The U.S. government does not pay for OCR auditors and the HIPAA in general, okay? It is, and if you look at just the last 3 years, 2014, 8 million. 2015, 8 million. Nope, sorry, I got it backwards. 2014, 8 million, 2015, 15 million, 2016, 24 million. Okay, so they have fined more in the last year than they have in the last 20 years combined. Okay, by the way, also there is the commentary from the new administration. HIPAA is about protecting information. It is not going to be repealed. They are not going to be backing off on enforcement. If anything, they're going to be more aggressive. Okay. As an FYI, you, as you saw, can be fined. You also can be sent to jail, or if you're, for example, your clients, your doctors that you service, they can lose their medical licenses for HIPAA violations. This also is not just at the federal level. This is also at the state level. Part of the changes in the Phase 2 audits was that your local state attorney general can pursue you on a HIPAA violation just as soon as the federal is. Okay. The Phase 2, you heard me talk about Phase 2 a couple of times. Over the years of HIPAA, they did a lot of analytics, and they called it the Phase 1 audit process. Last year, they implemented the Phase 2. The big things you need to understand is now you can be randomly audited just like a covered entity, okay? And the other big thing you got to watch out for is if one of your clients fails an audit, they will then audit you. If you fail your audit, they will then audit your clients in healthcare, okay? So that's not good for business. All right, so next slide. So at a high level, what you need to be doing, the minimum level of requirement to be HIPAA compliant is really a combination of these puzzle pieces. So first off, you have to be doing all the audits, or the assessments. I'm sorry, I have to be careful. I use the term audit and assessments interchangeably. Means something, it does mean different things to different people, but here's the deal. You have to look at your organization and assess whether or not you have risks in 3 categories, okay? Your privacy, your administrative, and your security. Okay, and there are actually 6 audits that are required. I will say at a high level, what you as security experts would consider a security audit is not the same thing as HIPAA. HIPAA is really the basic minimal level of security required. It's not asking complex questions like what level firewall you have. It's saying, do you have a firewall? Is it updated? Okay, so understand that you have to be doing all 6 audits. Okay, next thing is the law says you must have documented remediation plans. You have to have a document that says, I understand I did my assessments, I understand my gaps, and here is how I'm remediating those gaps. So this is not a, oh, we did it and we think we're getting to it. It is, by law, if an auditor calls you, and by the way, if you have a reported breach, this is what they will ask you for. The first thing they ask for is your assessments and your remediation plans. If you have those 2 things, often they will not go any further. But you still have to do the rest. The rest is, so for example, you must have written policies, procedures, and training. Okay, those need to be reviewed every year, which brings us to the next box, which is you have to have the term being document and version control. You have to be able to prove that every year you reviewed your policies and procedures to make sure they are current to either your business changes and to any regulatory changes. Training doesn't same thing. Has to be proven that you reviewed it every year. Now, it doesn't stop there. A lot of people turn around and say, yeah, my people signed a code of conduct when I hired them. We do HIPAA training every year. We're good. Not so fast, folks. The law says you have to be able to prove that each one of your employees every year attested, legally agreed that they have completely read and understood your policies, procedures, and training, and they're going to follow them. Okay? So it's not okay just to say we had a sign-in sheet and everyone saw a training, because then the government says just because they signed in doesn't mean they agreed, right? Doesn't mean that they said they understood it and they're going to follow it. So later when you have an incident or a breach, your organization is now liable, not an employee. Now to give you a real-world tangible example, we had a client, a blatant HIPAA violation, nurse accessed boyfriend's mother's medical records. Because the client could go in and prove that they had an effective compliance program, i.e., they could say, we can prove that this person legally attested that they completely read and understood that policy and agreed to follow it, so therefore we fired her for this violation. The client was, both the OCR auditor and the judge dismissed them from the case. Okay, so no liability whatsoever. That's the kind of story I like to, I think we all want to hear, right? Now, next thing is business associate management. This does absolutely apply to you. Remember that subcontractor definition I told you about? Okay, but let me explain it in general. You must have a business associate agreement in place with anybody you subcontract to, and your client must have a BA agreement in place with you before, both of you, before you share any PHI. Okay, you also have to have what's called a technical due diligence. You are not responsible for their HIPAA. You're responsible for making sure that they've given you some proof that they really can protect the information that you're sharing with them. Okay, and like I said, this is a really important issue for your clients. It is an equally important issue for you in that you can't use an RMM, you can't use a remote employee until you've had them either sign a BA if they're a corporation or attest to the policies, procedures, and training. Okay, incident management, you must have, this doesn't have to be a fancy program, but you have to be able to prove that an incident occurs, you have an investigation process, and that you document the results of that process and report appropriately. Okay, so this little picture here, this is what you got to be doing. So for those of you who are on this call, if you don't have this all in place, you're breaking the law. Okay, so let me say that in the kindest of terms. Sorry guys, you get caught on this, whether it's the $650,000 fine you saw for that IT group out of Philly, or much worse is what often these folks get involved in remediation efforts or notifying the patients, which can be another $1 million. And then if you take a look at some of the other ones, they're also involved in class action suits. So now that I've made that point, let's go through a couple of real-world examples. Okay, so the first one that's going to come up is why a risk analysis is not enough. Okay, Oregon, what occurred was unencrypted laptops and thumb drives were stolen. Okay, 1,300 records. Not that big a deal, except if you're one of the 1,300 records, right? So because this was a meaningful breach, it was reported. Oddly enough, this particular organization's defense to the government was, we absolutely were HIPAA compliant. We did 6 security risk analysis. Okay? And the second thing they said is, and we do everything remotely in the cloud. Everything is secure in the cloud. We use a HIPAA compliant hosting service, so therefore we're off the hook. Unfortunately, it doesn't work that way, folks. Okay? Two things about let me tell you what they were fined for. Lack of policies and procedures, lack of business associate agreement with their cloud storage hoster. Okay? So they weren't fined for the laptops or the thumb drives. They were fined for policies and procedures, period. Okay, so now brings you in, let me bring you to the second part of this. $2.7 million fine, that's a big nut. Okay, they had another $2.5 million in remediation efforts to notify the people who were affected. Okay, then they had a class action suit. I think that it's a $55 million class action suit. Okay, now remember folks, this isn't you. I agree this is a covered entity, but it could just as soon have been you. And remember, they got part of that fine was because they didn't have the right agreement with their provider. And that's why you're going to see so much pressure in 2017 of your clients saying, I can't do business with you unless you sign this. Okay. By the way, a good BA agreement, I'm sorry I didn't cover this, a good BA agreement actually limits your liability. It does not increase it. Okay, because what it really should be saying, and you should always have a lawyer look at them, is what it's really supposed to be saying is, you understand, we both understand we need to be HIPAA compliant. I'm responsible for what I do. You're responsible for what you do. Simple as that. Okay. The second reason why I brought this one up to you was this one particular incident in July drove the federal government to release a clarification. The clarification being, your HIPAA compliant organization, just because your hosting service is HIPAA compliant does not mean you're compliant. Okay, it's actually not at all. They're compliant, you still have to stand alone. Okay, so I'm going to go a little faster here because I want to make sure we complete everything before we get off this call today. So next one, which is going to be the importance of completing a BA and complete risk analysis. Hey, Northwell Memorial, they lost a laptop, right? What's it? Same thing. 6,500 records, but notice what the fine was for. No business associate agreement with their billing firm, and once again, failure to provide a comprehensive risk analysis. Okay, they didn't look at all of the elements. They just looked at security. Okay, so you're seeing a common theme here. If we go to the next one, the need for BAs. This has got to be the silliest reason. Okay, these guys, it's an orthopedic group. They had they wanted to get X-rays recycled. They were trying to do a good, good people and not help the environment. But the problem was the firm they hired, they didn't get a BA agreement. They didn't put a BA agreement in place first. Okay, so when this was exposed, $750,000 fine. Okay, same thing. All they had to do was have these people sign a document before they gave them the data. And this is why when I talk about what you're responsible for, we showed you what we have to do, but why it is so important you do it, or else your clients cannot do business with you. So what's the definition of a BA? Pretty straightforward. Are you anybody who's doing something on behalf of a covered entity or business associate where you're creating, receiving, maintaining, or transmitting protected health? So if you look at the next one, or if you can click, here's a list of BAs. So many people tell me, well, I'm a telephone company. I don't have to do it. I'm an IT equipment vendor. I'm a MSP. I'm a law firm, a consulting firm, storage company, temporary employment agency. It does not matter. These are all business associates under the law. Okay? Interesting opportunity. Another presentation we'll be doing another time. This is a great opportunity for you guys to be chasing business because all these people got to be HIPAA compliant, and there's opportunities for you to help them with their security needs, obviously. Okay? So next one. So what changed for you directly is you are directly liable for violations. You do have to satisfy technical, administrative, and privacy safeguards. Okay? You are not responsible for the privacy rule, but you are responsible to help your client satisfy the privacy rule. And the example would be, if I have an incident and I need to prove, and one of the rules, one of the responsibilities, I'll talk about one of the responsibilities is, if as a covered entity or as a BA, you have to be able to document any time someone looked at my personal records, which means you might have your covered entity saying to you, hey, I am in an audit and I need you to provide to me a report on who looked at those records. And so therefore you are often called in to help support the privacy rule. And then ultimately, as I talked about with contractors, you are responsible for the people who do work for you. Okay, same thing. You got to get a BA agreement, got to do your due diligence. So let's talk about BA agreements. Okay, whether it's you, covered entity to you, or you to your subcontractors, it says everyone's got to be HIPAA compliant. Okay, your responsibility to help a covered entity with privacy requirements. You are you are responsible for this with your subcontractors. It is required before you do anything, not post. There were some grandfathering clauses that existed in the past when the omnibus rule was first put in. They have since expired. So if you have anybody saying, well, I've been doing business with them for many years, I don't have to do it. Nope, that's not the way it works anymore. Your grace period is over. You should not be doing business with anybody in healthcare without a BA agreement in place. It is actually the protection that you need from it. Because without it, if there is a breach, government says you're both wrong, we're fining you both. Which brings you up to our next one, which is your liabilities. Okay? So you are directly liable, okay, for what is, okay, so I talked a little bit about that use and disclosure document. in simple terms, you need to make sure that no one can get access to this information and that no information is being shared in a way that was not, that did not, the end client, the patient, did not give permission for. Okay? You are required to give breach notifications to your covered entity. If you have a breach, you can't just, let's not tell anybody, maybe no one will find out. You got to tell your CE, the covered entity. There are rules about the notification to the patient, etc. Okay? If someone wants a copy of their PHI, okay, you have to support your covered entity in giving them that. So if you're a maintenance, if you're a storage facility, you still have to, if someone wants something, you have to be able to help them get to it. Okay? You have to disclose where PHI is required. So if there's an investigation, you have to be able to explain where this PHI that was handed to you, who touched it, why they touched it, how they touched it, what happened. Okay? The next thing is also what's called minimum necessary. What that is often I hear this, you're doing a maintenance, right? You're doing some sort of remote monitoring, servicing something. Legitimately, if there was a question asked about what you're looking at, so, okay, do you have George's record? Can you see George's record? Yes. Okay. What's not considered appropriate is, yep, I can see George's record. I see he's at the following 3 surgeries. He's taking the following medicine, et cetera, et cetera, et cetera. Minimum necessary. I asked you to confirm his name. That's what you confirm, nothing else. Okay? Accounting and disclosures is you're responsible to explain to anybody that you are taking PHI. Okay, and by the way, as an MSP, understand you got to be fully HIPAA compliant, so that if I asked you, please let me know when one of your guys was doing an RMM event and saw that somebody's records, I need you to be able to document and prove that to me, because if the client asks me or the patient asks me, I have to be able to answer that. Okay. Next one. What do we got coming up next? Okay, so as we're nearing the end, folks, and hopefully we'll have lots of questions for me in the last couple of minutes of this. So you got to be doing all this. This is not optional. This is the fundamental requirement of being HIPAA compliant. The only thing you're exempt from is the privacy rule, which has to do with how you communicate with the patient. So do not fall prey that if someone says to you, oh, we don't have to worry about this because, or I saw some webinar somewhere and they said, oh, we don't have to worry about all this. You do. And if you're not worrying about it, your clients can't do business with you, and ultimately you're opening yourself up to some serious fines and liability. Now that I've given you all this kind of scary, negative hoopla, let's talk about what's the benefit of doing this, right? So if you look at what is the benefits, this is a way to differentiate your firm, okay? Being HIPAA compliant, and the example I would give you is Fitbit. Fitbit, the exercise tracking device, they put out a press release, they were HIPAA compliant, stock price goes up 26%, okay? So just being HIPAA compliant and being proactive about sharing that in the market will garner you clients. It will also help you with number 2. For those of you who've ever told a client that you're not willing to sign their business associate agreement, understand there's a firm like mine in the country that when that question comes up, our first answer is, please go find another vendor, okay? If they are not willing to sign a BA agreement, you cannot do business with them under law, go find a new one, okay? Healthcare is a big, huge, lucrative market. Okay, I hear often people saying they're afraid to go into healthcare, doctors don't have any money. But understand, healthcare today, okay, especially in what is under vendors and business associates, you saw that list, it's a huge opportunity for you to be chasing that market. Offering compliant services as part of your offerings. This does increase efficiencies, because at the end of the day, what you're really doing is you're documenting your processes and making, and in that process, often you're identifying where you're doing things that were, whether you stopped doing them because you were breaking the law by doing them the old way, the new way often is just much more efficient, right? So you can be, I've seen, like in our case, where using tools, automated tools like ours, the time and effort to do a security audit got dropped by 2/3, okay? 4 to 6 hours versus 15 to 20. Okay, so it's just much more lucrative for you. The last thing I would tell you about it is if you are truly understand HIPAA and you can explain it intelligently to your clients, when you are trying to convince this person or this organization they must upgrade something, it is a hell of a lot easier to say it's not just because you think it's a risk, but because, oh, by the way, you're breaking a federal law. And if you are caught doing this, you will be subject to the $24 million of fines like we saw people last year and the hundreds of million dollars of class action suits. So, okay, we got roughly 10 minutes left. If you have questions, I would gladly answer them for you. Please have at it. If not, I'll tell you my big ones.
Hey, thanks, Mark. Really appreciate it. Great information. Everyone, we are running a little bit long, which is okay, but we got about 10 minutes. And we do have some questions here. I'm going to ask the first one while Laura gets ready to ask the rest of them here. The one question, Mark, for you is, one of the gentlemen on here today is a cloud provider, and they have clients that are interested in using their platform in the health insurance sector. And he's really believing that he's going to need a BAA after listening to what you have to say. And he's wondering what the costs are to get one in place, to get it created.
So, yeah, so the cost is really, you got to be HIPAA compliant, okay? And that is depending on where you are in your compliance. Could be do it yourself and have no cost. You can go to hhs.org. Has really improved as a website. For example, specifically to your question of a BA agreement, there is an outline of what is a standard BA agreement there. Although I would recommend, obviously, that is somewhat of a generic one. It is not a bad idea to have a legal counsel, review that and make sure it protects you in the appropriate ways. Do remember that your BA agreement is not meant to be a contractual agreement, like as in your terms of service or master services agreement SOWs. It's just meant to address the issues of the information, in this case, EPHI being shared. Okay, so.
And I will mention on here too is, because I always ask whenever we're doing, ask gentlemen like Mark to come on or women to come on and do their presentation here, this type of a presentation, which is educational for our partners. It's not to pitch their products, but if you work with Compliancy Group, they have a great product. You can make some really good money with your clients with them, but they will also cover you. They'll work with you to get you Compliancy Group HIPAA certified, and you can put that on your website, and they help you be compliant. So by engaging with Compliancy Group, not only do you have a great product that you can take to market and generate additional revenue off of a lot of other security pieces. And one of the reasons why Mark goes to our security shows and stuff like that, our road shows, is because his product is a great lead-in for a lot of other CCAS type of products that you're going to want to put in place to help your clients get covered. But they also cover you, so that you have a nice piece on a HIPAA compliance logo on your website and you know what you're doing. Did you want to add to that a bit, Mark? I don't mind because I brought it up. So.
No, thank you. So I will try not to go too overboard. But in the end, what we do with a lot of folks in the market is we let you add compliance as a service as an entire new line offering for you. Okay, and it's not expensive. Part of that, as Clinton said, is part of that is you actually are put through the process of becoming HIPAA compliant, and our solution is a total solution. So everything you saw in that wheel is built into our program, and depending on the size, we're talking a couple grand a year. Okay, this is not a big, expensive, hairy, ugly thing, but we see MSPs in the market, signing up. Our commitment to you is if you do choose to work with us, our goal is to get you 5 new clients in the first 90 days, okay? And often our partners see that they are doubling their billings with an organization by adding compliance as a service. And I think we're doing a webinar in a couple of weeks where we'll be talking about that compliance as a service.
Yeah, we have a snapshot webinar coming up in about 2 weeks, which is all about what he's doing with managed service providers. They do work with about 300 managed service providers today, and that's growing. And we have a snapshot webinar coming up in about 2 weeks, so watch for your invitations on that. I will make sure that everyone on this gets it and gets that. Laura and I will make sure that you get the invitation for that snapshot webinar, so you really should attend. It's a great program on that. Another question was, is Compliancy Group in the SASMAX platform? Yes, they are. Go up to SASMAX, type in the search feature in SASMAX, type in Compliancy, and you will find their profile, their information up there. And Rodney, you asked a question, so you can also ask John. John can, your success manager, our partner success manager, can get you in touch with Joe over at Compliancy Group to walk you through how their program works, what their resale program looks like, and stuff like that. So you can reach out to John as well for that, or you can hit the I want to talk to you, or I want to talk to someone on the profile in SASMAX to do so. Laura, do you have some more questions?
I do. So Mark, when you're talking about the privacy rule and it not applying to the BA, to the MSP or the BA, does it apply in this particular situation? Because I remember this happening to somebody else I knew way back when I was doing a lot of healthcare vertical stuff. A technician was in repairing the computers at the covered entity, the medical practice's office, and they saw a record showing that a teacher where their kid went to school had cancer. And it was pretty far advanced, and they were shocked that they didn't know anything about it. They happened to go home. They were talking to their wife when they got home. The kid who happens to be in that teacher's class overheard, went to school the next day, and said, did you know so-and-so has cancer? Which created a major problem because, number one, it violated her medical privacy, but it also created a problem in the school system because now there was a potential threat of her job, and she reported that up to the compliancy groups. And the doctor's office ended up getting in trouble, and the BA ended up getting in trouble. How does that get handled, and why is it so important?
Well, so the concept, there's a couple reasons why HIPAA came into existence. One of it is the unfair exposure of someone's sensitive data, right? So losing your job and, someone dying of cancer. These are highly personal things and should never be shared unless I want to share them, right? The rest of it has to do with really, the importance in the healthcare world of being able to share information. So, that story is just like a disaster all over the place, right? But unfortunately, or let's say the fortunate thing is some basic blocking and tackling under what is an effective compliance program would have avoided that, right? The technician would have known if they saw that they were not allowed to repeat it. Often there are we talk about minimum necessary. There may have been other ways to address issues that where as much information wasn't being exposed, right? The concept of confidentiality is also a big part of the BA agreement, right? In that, part of what we're saying is when you do come across this stuff, you're not allowed to go home and discuss it with somebody. You're not allowed to do, if you take the privacy rule has a lot to do with when a doctor and a patient are talking to each other, rules of engagement, right? And those are the kind of things that you have to, you really, if nothing else, a simple mistake like the example I gave you with this mother, the boyfriend and the girlfriend and the boyfriend's mother, where the boyfriend was upset. Mom, why'd you go to the doctor? I don't want to discuss with you. They checked. That's a multi-million-dollar lawsuit. When you see suits like that, by the way, they go beyond HIPAA. Okay, the HIPAA violation was actually a straightforward incident, right? And therefore could have had a $50,000 fine applied to it or much more. The real issue is now you have serious lawsuits in place, right? And in today's litigious world, that kind of negligence is considered, gross misconduct, and you can lose your business over it. The last thing you want to do. I will stress though, basic HIPAA doesn't have to cost a lot of money. It is better for you to run your business with, and will only return you higher returns rather than ignoring it, especially for vendors. I make this case to covered entities all the time, right? But the issue is for a BA, being HIPAA compliant is it's a differentiator. It can open doors for you. So use it, right? To Clinton's point, we offer a seal of compliance. It's part of what we do, where if you are working with us, you have a third-party verification or validation that your organization is better than the next person's. And please make use of it. We've seen, we saw one of our hosting services win $1 million deal over another one. We work with both of them, but one is a user of our product. One said, oh, we're HIPAA compliant. We don't need to use your product, but we like to refer to you. And unfortunately, it cost them $1 million.
All right.
I think if we can go back, I'm sorry, Laura, but because there's still a little doubt in my mind with and I'm sure there's some in the audience, when Laura brought up that example. If the reseller in that situation had a good BA in place and they showed their process and procedures how they were teaching their employees not to talk about these things, then their risk would have been mitigated?
Yeah. Oh, yeah. So, and I'm sorry because there was a lot of example there, so I didn't necessarily catch all of it. So, if you can prove, so breach happens. Let's just narrow this. Breach happens. Investigator comes. okay? BA agreement gives you the separation that if my person did it, I'm responsible. If your person did it, you're responsible. So that's the first thing, okay? Just because it happened is a horrible thing, but if you could prove you had an effective compliance program, the $1 million fine for the incident would have not been levied, okay? Because it's okay for someone to make a mistake. You know, that tech that made the mistake, that saw the information, that shared the information with his family, whatever, that was a mistake, okay? The issue is who's liable for that mistake. Now, in the case of if you were fully HIPAA compliant with BA agreements in place, the organization, your firm, would not have been liable for it. They would have said, unfortunate incident, you might have a slander suit on your hand, with, you know, in between two people, but the organization would not have been fined. Now, remember I mentioned disciplinary guidelines? It probably means you had to fire your tech, okay? Because that's one of the ways you would have proved you had an effective compliance program,
Right.
okay?
Exactly.
Or at least, you know, did something that showed that they were disciplined for the mistake.
Great. Yeah, that's right.
That's
what I
what
thought. I want to make sure we clarified that, is that the solution provider himself would not have gotten in trouble as long as he showed that he trains his employees on it and that he disciplined the employee. Then,
well, did all his audits, had his remediation plan, policies, procedures, training, everybody tested to him. There's a lot. What happens is you really have to be doing all of it, and I'm not saying it as a person who sells a service. The law requires, the way the law is written, is you must be able to prove that you have this effective program, and the only way to prove you have an effective program is to have all of the, you know, is to have everything in that wheel: your audits, remediation plans, policies, procedures, your employees attest. If you're as a business associate, you might have subcontractors. Any incidences you have, are you tracking them? Because if you had all that, then it's simple. It was a mistake. You know, something bad happened. There was no negligence. Because by the way, they don't have to fine you. You can have a horrible breach. I mean, we've seen this many times. You can have a horrible breach, terrible incident. And I gave you the example of the one with the nurse. There was no fines, no corrective action plans. It was that's a horrible thing that happened. Right?
Oh, no, they were
no negligence.
They got rid of the girl, and they actually had a plan in place, and they can't help it if someone goes and does a stupid mistake. And it's your cover. You gave them all.
Hate to say it. You know, that may sound crass. We cannot fix stupid.
No, you can't, and you got a CYA too.
Yes, so a lot of this is really protecting. You know, first of all, the concept of protecting patients' information is a really cool thing, right? You really need to be doing that. But then you really also understand you're protecting your firm, right?
That's right.
You know, you've invested. You know, if you're most of the MSPs we work with are privately held organizations, and you know, this is many years of investment from you. You know, blood, sweat, and tears. The last thing you want to lose it over is because you didn't sign a piece of paper.
Yep. Well, okay. So the other questions, folks, there's a lot of great questions here. We'll get back to you on those. We are 5-6 minutes over now, and I appreciate everybody staying on because you all have. You know, you can find Compliance Group in SASMAX. If you're a SASMAX customer right now and you don't know who your partner success manager is, you know, reach out to me. I can help you get in touch with Mark or any of our other great vendors that we have in the marketplace. We'd love to learn more about your business and how we can help you, and we're all here to help you too. Not just our vendors. We're here to help you find right products for your right business model for the types of clients that you have. So reach out to us. If you are not registered in SASMAX today, we will be in touch with you after this at any given rate. And take the opportunity to get registered. It's pretty simple to do. And take a look at what we have to have and speak with one of our partner success managers who will learn your business and be able to help make suggestions of different products and services that might be good for your clients, or if you're looking for something. I know you're all very busy. We all tend to be a bit smaller companies. Most of us are on here today, and doing your research and development can be really hard with, you know, you might even be still billing yourself out there, or you're busy working in the business. Little time to work on the business, and we can help you work on the business when it comes to product research and development. So, Mark, thank you very much today. I appreciate it.
All right, thank you, everybody. We really appreciate it. And it is a great program, folks. Participate in SASMAX. We highly recommend it.
And Laura, thank you very much as well. I appreciate all you do here at SASMAX and making these a great success and great information for all of our partners and our partner community.
My pleasure. And everybody will be sending out the recording of this. So if you want to go back over it, I know there's a lot of content. If you'd like copies of the slide deck, please email me and let me know. And you can just click on the link inside your invitation that has my email address on it. laura.stewart@sasmax.com, and happy to get any questions you need answered if you didn't get a chance to ask them. Have a great day, everyone.
All right,
Thank you.
Thank you. Bye-bye.